While we might hope for a short walk through the field of labor and immigration law, um, I wish, I tend to get sidetracked and I probably go on too long about this or that. Um, I ask in the outset, why are we looking at unions, collective bargaining units, and immigrants together? Um, at least the book that I created these in put them together. And I think they're kind of, maybe it makes some sense that these are sort of external forces to earn internal difficulties. And, so will they absolutely make sense together? Probably not. They're a little bit separate, but maybe they work. Let's look at it. Federal versus state law. One of the things we're finding, and Missouri just passed its own right to work statute. I'm not certain if it's in place yet. Usually statutes have some time before they become prevalent. I started this and all of a sudden I'm kind of a little lightheaded. One of the ones I found early on was Alabama in 1954 gives workers a right to not join, essentially forbidding a closed shop. Now, this is a response to some federal regulation that I list below, Taft-Hartley, which a lot of writers concede or say really kind of expanded union reach. And Taft-Hartley, I believe, is 1943 or 45. We go into 1935, the National Labor Relations Act creates the NLRB, the National Labor Relations Board, which now gets us to the Department of Labor. It's a great first Secretary of Labor was the first woman cabinet member, the phenomenal Frances Perkins. If you want to study a really interesting person, there you go. She was a little tiny girl who had basically 12 things she needed to have Franklin Delano Roosevelt approve before she would even consent to work for him. Among them was the 8-hour day. She also did some things about what is the shirtwaist fire? I can't remember the real bad fire in New York. I'm sorry, I'm blanking on it, and maybe it's in these slides, where 121 workers perished in a garment district because they had locked all the doors to keep the people working. So a lot of what we're talking about comes out of Frances Perkins, who was a great friend of Eleanor Roosevelt, who, if you really want to study a great American hero, you cannot go wrong with Eleanor Roosevelt. But Taft-Hartley expanded the ability of unions to come in. And let's look at the history of this. If we go to Jay Gould in the building of the Union Pacific Railroad, if the workers decided they were going to have a sit-down strike, yeah, that was close. It probably was there. We're not going to pull that out. Had a sit-down strike, Gould would just find new people to work. He would just tell these guys, okay, you're fired, you're gone. Well, they're out in the middle of Nebraska. Good luck getting home. We're not taking you home on the railroad, that's for sure. You made a bad choice. Things got worse and worse and worse and worse. There's a lot of non-union strife over all the years. When I was a kid in the 60s, we had a lot more strikes than we do now. I think in part because we've come to a bit of a state of maturity among employers who can find good things in having union shop. And if you read, for instance, the railroads, if you read the annual reports for stockholders of the railroads, they all actually sing the praises of having union workers there and having union rules in place. Big progression from the days where we had gunfire at the Ford plant, and the president had to intervene. Um, anyway, it expands union activities, protects pre-organization employer speech. It does not protect post-organization. So the employer is free to say things about, hey, don't join a union. We're going to do X, Y, and Z. We'll always do that. You know, if you want to look at a company that has successfully kept unions out, the Coors Brewing Company, been a lot of pressure by the Teamsters and other organizations to organize Coors. Their workers have always voted it down. Last year, I believe both Boeing in South Carolina and VW in Tennessee, a lot of push by the unions, to both of which are right-to-work states. Missouri became the 27th, I think, right-to-work state. I believe there are now 28. Prior to the election, we were at 26. This is the election where Mr. Donald Trump was elected president of the United States of America. Anyway, employers can make all kinds of promises before organization, and they have to live up to them after. There was some push during the Obama administration to permit card check, which was essentially, we'll write your name on a card, hand it to you, and you either say yay or nay on whether you want to have a union come in. A lot of pushback against that because it destroyed anonymity. They had a real check of who voted yay or who voted nay. This is meant to be organized in an anonymous fashion, just like we vote anonymously. The Taft-Hartley does permit the president to intervene. The president has intervened in national strikes quite frequently, railway strikes, and Reagan essentially ended the union and the air traffic controllers. He fired everybody. And so they had to redo it all. The Railway Labor Act has similar protections built into it. I'm not going to go into much detail there, but those of you concerned in railway law need to know that that is sitting there. Essentially, let's look at how do we organize a collective bargaining unit. The workers or groups of workers or outside agencies, AFL-CIO, Teamsters, other, the National Education Association, the American Federation of Teachers, or it may be that locally teachers want to do this. There's I can see the actress's face. That Sally Fields has a movie, Norma Ray, I think, that maybe details this. I've never seen the film, but it is, I believe it's a garment factory in North Carolina or down in the South, about the need to unionize. And, sometimes we think, oh, the unions are gone. Well, I want you to look at a couple things, and I may have slides on this, but the unions in many ways have given a lot of us more benefits than we might otherwise have. They've negotiated for health care, employee-provided health care, which is a little odd that the Affordable Care Act kind of punishes union-based health care, because that's really the base of the Democratic Party is union workers, but and union donations in. It's a little odd that that's the Cadillac plans they're after. But the unions have also probably vouchsafed for all of us things like the availability of the 401k. They sort of began the thinking process of, hey, let's provide for people in their old age. Let's, so did the IRA come out of that? It's probably a stretch, the individual retirement account, but not really, because Congress is sitting there looking at it. Well, we can really probably only reach to companies that have 30 or 50 or more employees, and those are the only ones we can legislate on, because anything smaller than that, it's a pretty strong argument that's not part of interstate commerce. Once you start getting scale, We can argue whether that really works or not, but the courts have kind of said it's hard to judge exactly when an entity is or is not interstate commerce. Anyway, sidetrack there, but we may owe a lot of this stuff to the unions. So let's not be real quick to throw unions under the bus. There are also advantages to employers for having a union in place, in that even though the grievance process can make it challenging to get rid of a worker, if under the grievance process we get that worker to be expelled, a lot of the claims of discrimination or other things go by the wayside, because in order to be fired, you had to breach company rules. All right. So anyway, but let's look at, assume there's no union in place. If 30% of workers want to consider joining a CBU, they can so certify and send it off to the National Labor Relations Board. If the NLRB is satisfied upon investigation that at least 30% of the workers want to put it to a vote, then they can set an election. It is meant to be a contested election. It's a simple majority. I was a little upset with the vote at St. Louis Community College, because they only set it on a certain day, Sunday, and I think it was only at Forest Park Community College. You actually had to travel. I work at Merrimack. It's close to my home, I grant you, but I was unable to go vote that day. Huge majority to vote it. Could we have done a mail-in vote? Could we have done an electronic vote? Maybe we could. If the employer consents that we're going to go union, there's no NLRB supervision. There's also an opportunity to decertify. St. John's Hospital, about a decade ago, went union. 3 or 4 years later, the nurses said, we want out. And they decertified the collective bargaining unit. It's a pretty rare event, but it is possible. A lot of what I deal with in my, at least UMSL class, I deal with the railroads primarily. They've found benefit in having union guys there, because the union guys kind of tend to get everybody in line. Hey, you can't do that here. You're going to bust us up. We're not going to have a job. They're going to get rid of us. Anyway, if the employer or any other worker wants to contest it, then we're going to have a simple majority voted in to certify a CBU. I believe that the union only got 43% of the vote down in the Tennessee one, and I don't remember the Boeing. But both places, as I remember it, voted against having the union in. Is that the right thing to do? I don't know. That's how they voted. All right. So once the election process goes on, the union people are able to gain access. It's limited access to the workplace for promotion. They may not be able to go onto the shop floor because they're not necessarily trained and they're not very safe doing anything there. Sorry, I've got a doggy I've got to attend to. Give me a second. I'll be right back.